This video addresses the DC temporary protection orders and civil protection orders, commonly known as restraining order. The TPO, or temporary protection order, is initially sought for by a petitioner who will file a petition for TPO/CPO, and they will attach to the petition affidavit, which will detail and allege the acts that constitute a criminal offense or a threat of a criminal offense. Because those TPO hearings are unilateral hearings, only the petitioner will appear in front of the judge. Most of those hearings, the TPO orders will be granted as long as they can allege sufficient facts to support that either a criminal offense has been committed or threatened to be committed. Then there will be enough basis for the judge to order a stay away and to order the respondent to remove himself or herself from the property and relinquish property, and even grant of child support and child custody. A temporary custody and support order will be issued sometimes. But once the TPO has been granted, there is a CPO hearing that will ensue the TPO hearing in 2 weeks or 14 days by law and by statute. At those hearings, the respondent will be served with the copy of a petition and the allegations made against them, and they will have an opportunity to be in court and defend themselves against the allegations in the CPO hearing. It is very important at that hearing to have a very competent representation and to be fully ready to go forward with a trial, because in a CPO hearing, and the judicial officer, as long as they can establish there's a good cause shown, or there's a belief that there's a good cause to believe either a criminal offense has been committed or threatened to be committed, can issue an order that order the respondent to stay away from the petitioner for a period of 1 year, not to have any contact with the petitioner, to vacate a joint property that's owned by both the petitioner and the respondent, a marital home potentially, or a home that's leased jointly, or relinquish property, car, or different type of property that's commonly used. But more importantly, that judge can also address or issue a temporary child custody order or support order, or even maybe a stay away order from a children in common, depending if there's been any allegation of abuse or assault against the children as well. So, and as well as attorney's fees. So the CPO judge, a judicial officer, has a broad discretion to order a multitude of categories of family law, which will normally have to be a separate filing in separate proceedings. And with that alone, in a quick hearing, that could be established or ordered against the respondent. So going back, it's essentially critical to make sure that you're well represented at the CPO hearing, and that you are there and you're defending yourself and present evidence contrary to what's been alleged against you. What also makes the CPO orders very complex and very serious are the fact that any violation of the CPO order, the terms of the order, anything the judge orders at that point, at that CPO hearing, after having evidence adduced, will be a violation. Any violation will be a criminal offense. So not only you have a CPO order that you have to adhere to, but if you violate any of those terms in a period of a year, which is normally what the CPO order will have, a 1-year order, then that would be a criminal offense. It could be prosecuted by U.S. Attorney's Office. So going back and emphasizing this one more time, it is important to, right after being served by a TPO, temporary protection order, you have essentially 2 weeks to prepare yourself and to have very, very competent, strong representation in court for the CPO hearing, to make sure that you are not, in fact, issued an order against you that will last for a year, an order that will address your home, your children, your property, and it's essentially a very broad and serious order that can limit many different things. For more information about DC criminal and family laws, you can visit our website, familylawdc.com.